Well, with stunning speed indicating a rare case of judicial eagerness to move swiftly, the 11th Circuit Court of Appeals this evening crushed the case of Donald J. Trump versus the United States of America with the kind of finality that Donald Trump does not know how to process. It was as if the three-judge panel went out of their way to write the words that Donald Trump's parents apparently never said to him, and that he doesn't allow anyone close to him to ever say to him. When the judges wrote to Donald Trump, the answer is no. The judge's unanimous opinion says this appeal requires us to consider whether the district court had jurisdiction to block the United States from using lawfully seized records in a criminal investigation. The answer is no. The case of Donald J. Trump versus United States of America is a civil lawsuit brought by Donald Trump against federal prosecutors investigating his possession of government documents, including classified documents, at his Florida residence. It is a lawsuit, the likes of which we have never seen before. No federal judge has ever seen a lawsuit like this, a point made repeatedly by the three appeals court judges, two of whom were appointed by Donald Trump and the other by President George W. Bush. The special master in the case, Judge Raymond Dearie, who was appointed by Florida federal judge Aileen Mercedes Cannon, had already canceled a hearing scheduled for today in the special master process, and now no such hearing will ever occur. And Judge Raymond Dearie can go back to his regular duties as a federal judge because Donald Trump's special master game is over. That game bought Donald Trump 3 months of delay in a judicial system where 3 months of delay is the blink of an eye. We saw the appeals process work in this case as fast as we have seen it work. This is the exact opposite of the way a Washington, D.C. federal court and appeals court handled an even simpler case, which was the demand by the chair of the House Ways and Means Committee to obtain copies of Donald Trump's tax returns. There is a very simple federal law that leaves the IRS absolutely no discretion whatsoever in handing over tax returns immediately to either the chairman of the House Ways and Means Committee or the chairman of the Senate Finance Committee whenever they might request any tax returns. That is the law. The law could not be simpler. But Donald Trump bought 3 years of delay in the federal court system, a delay caused principally by a Trump-appointed judge at the district court level, Judge Trevor McFadden, who just sat on the case for those 3 years. District court judges are never named in appeals court opinions about their rulings. They are always referred to simply as the court. And so the now thoroughly disgraced Judge Aileen Mercedes Cannon's name does not appear in this appeals court opinion, which so thoroughly condemns her work. The judges issued their opinion 1 week after hearing the oral arguments in this appeal. It is common for months to pass between oral arguments and the issuance of opinions like this, but not this time. Every time the Justice Department has appealed a portion of this case and eventually the entire case to the 11th Circuit Court of Appeals, the 11th Circuit has moved as quickly as possible. On September 16th, the Justice Department filed their first appeal with the 11th Circuit asking to exclude classified documents found at Donald Trump's residence from the special master review. And 5 days after filing that appeal, a three-judge panel granted that request. Then the Justice Department concentrated on appealing the entire case to the 11th Circuit, and the 11th Circuit moved that appeal as quickly as possible. More than any case Donald Trump has ever been involved with in his life, this is the one where Donald Trump wants to delay and delay and delay, because this is the one where Donald Trump faces such serious potential criminal indictments. If Donald Trump is indicted in this case, the title of that criminal case will be the opposite of the title of the civil case that Donald Trump just lost. The civil case in the 11th Circuit, effectively extinguished today, is titled Donald J. Trump versus the United States of America. If Donald Trump becomes a criminal defendant, the title of the case will be the United States of America versus Donald J. Trump, and Donald Trump will finally experience what it is like to stand in a federal courtroom accused of crimes by the full power and authority of the United States of America. There is now nothing procedurally standing in the way of Special Prosecutor Jack Smith moving with all deliberate speed to bring criminal charges in this case, if criminal charges are going to be brought. There is nothing in the way now, nothing. There are very few federal court judges who will ever provoke an appeals court opinion that makes a mockery of them, the way the 11th Circuit appears to mock Judge Aileen Mercedes Cannon. The appeals court says the law is clear. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant, nor can we write a rule that allows only former presidents to do so. Either approach would be a radical reordering of our case law, limiting the federal court's involvement in criminal investigations. And both would violate bedrock separation of powers limitations. Accordingly, we agree with the government that the district court improperly exercised equitable jurisdiction and that dismissal of the entire proceeding is required. The district court improperly exercised equitable jurisdiction in this case. For that reason, we vacate the September 5 order on appeal and remand with instructions for the district court to dismiss the underlying civil action. That means that Donald Trump's favorite judge of all time is going to have to personally dismiss this case after the 11th Circuit remands it to her, which is legal language for sends it back to her. They make you fix what you broke. That's what appeals courts do to district court judges in cases like this. So the final action in this case will be Judge Aileen Mercedes Cannon humiliating herself by dismissing the case she never should have allowed in her courtroom. The 11th Circuit opinion notes that Donald Trump's lawyers are, in effect, asking for special treatment for Donald Trump simply because he served one term as president of the United States. The 11th Circuit wrote, in considering these arguments, we are faced with a choice: apply our usual test, drastically expand the availability of equitable jurisdiction for every subject of a search warrant, or carve out an unprecedented exception in our law for former presidents. We choose the first option, so the case must be dismissed.